Let us begin. As I said, I'm Kevin Bell, Professor Kevin Bell, and I'm the Director of the Castan Centre for Human Rights Law in the Faculty of Law at Monash University. I'm also recently appointed a Commissioner of the URUC Justice Commission, a Royal Commission established to undertake a transitional justice process in the state of Victoria with respect to Aboriginal people. Therefore, it's with strength that I acknowledge the traditional custodians of the land from which I'm calling today, the people of the Kulin Nations. I pay my respect to their elders past and present, and I extend that respect to other Aboriginal people who may be calling into this event today. Welcome to the event Charting a Better Recovery. It's a pleasure for us at the Castan Centre to partner with our very good friends, the Human Rights Law Centre, and to have indeed one of them, the Executive Director, Hugh de Kretser, speaking in this seminar today. He's one of four eminent speakers that are frontliners on the issues associated with the challenges of the pandemic and how a stronger human rights focus, like an Australian Charter for Human Rights, might feed into the recovery. The Castan Centre, can I just interpolate, will be hosting some other great events that you might like to attend. We're pasting links to those events into the chat, and you can access them there, or you can simply access the Castan Centre website and see them there. The three events I have in mind are the human rights of older persons in aged care, at which the special rapporteur, or rather independent expert to be technically correct, on the human rights of older persons will be co-presenting. That's on the 8th of June. Women and International Peace and Security in Afghanistan on the 24th of June, and of course our conference on human rights, the annual one, missed last year, making up this year, on the 23rd of June. Before we commence, can I just ask you to use the Q&A chat function for your questions. They will be addressed after four individual presentations, about 5 minutes in duration from each of our speakers. Now, by way of background, the twin crises of the COVID-19 pandemic and the first economic recession in 30 years have highlighted and deepened cracks in our community, highlighted inequalities, lack of inclusion, and showed the fragility of many things that we have taken for granted. In tough times, many have struggled to keep make ends meet, keep a roof over their head, and ensure that they can access services like health and education. And yet, during the pandemic, economic support ended homelessness, regrettably only temporarily, reduced unemployment, regrettably only temporarily. As public attention and political decision-making focuses on what the recovery looks like in 2021 and what lessons need to be learned so that future crises are better handled, we think it's time to look at who is left behind in the recovery and how a stronger human rights focus, such as might result from the enactment of an Australian Charter of Human Rights, can make our laws, our policies, and our services better. Let me now introduce our speakers, and it is with particular pleasure that I do so, because we've had four speakers, each eminent in their field, who, as I said earlier, will first address you for some 5 minutes, and then we'll have a discussion about the issues that arise with respect to this topic. I'll introduce the speakers all at once so as not to interrupt the flow of the seminar. The first speaker is Cassandra Goldie, Chief Executive Officer of the Australian Council of Social Services, who will be known to most of you watching. Pardon me. Dr. Goldie is, as I've said, the Chief Executive Officer of the Australian Council of Social Service, the national peak body for the community sector, and a strong, fierce advocate for tackling poverty and inequality. Cassandra has deep public experience in public policy, particularly with respect to economic, social issues, civil society, social justice, and human rights. Cassandra actually has a PhD in human rights, which focused upon homelessness, one of the most important issues arising out of the pandemic. She is also a passionate media commentator and conference presenter, so we're very much looking forward to hearing from Cassandra. Next is Mary Sayers, who's the CEO of Children and Young People with Disability Australia. She has been such since July 2019. Over her long career, she has worked across policy and research, advocacy and service delivery, and has family experience of disability as a parent. She too is a passionate advocate for the rights of children and young people. Katherine Temple is the Director of Policy and Campaigns with Consumer Action Law Centre. That is a campaign-focused consumer advocacy organisation that offers legal and financial counselling assistance. Katherine is passionate about social justice and advocates for law reform across a range of economic and social issues, including consumer credit, insurance, energy, and telecommunications. I've had a long association with the Consumer Action Law Centre. It was established back in the day when I myself was active in the community legal centre movement. Then comes Hugh de Kretser from our partner in this seminar today, the Human Rights Law Centre, of which I've already said he's the Executive Director. He joined that centre in 2013 as the ED and has extensive human rights, legal and advocacy expertise at the local, national and international levels. He's performed a range of legal policy and governance roles, including working as the Executive Officer of the Victorian Federation of Community Legal Centres, making me remember my own role in founding that organisation and serving as a Commissioner on the Victorian Law Reform Commission. Welcome to all of you. Can I now ask for your individual presentations? Cassandra, I will ask you to go first, then Mary, then Katherine, then Hugh, in other words, the order in which I just introduced you. Thank you, Cassandra.
Thanks, Kevin, very much, and to the partners for the opportunity to be involved in this very timely coming together with the human rights analysis, because as Kevin highlighted, I do have this background in human rights law, and whilst I've been working very much sort of upstream in economic, social and environmental policy for some time now, can I tell you, when I want to work out whether something is at the point of being intolerable, it is always the lens of the human rights analysis that I continue to find the most useful, whether or not we use it in a more public sense. So I did want to, we've just come through, of course, a really important federal budget, which is meant to set us up for the next phase after some pretty terrible 18 months where globally and also domestically we've been challenged on so many fronts in our basic sort of protections and fulfilment of human rights. As Kevin alluded to, we demonstrated that with Australia being one of the wealthiest countries, we are alongside Switzerland, have the highest level of median wealth in the globe, which touches on it to the maximum available resources in terms of progressive realisation of economic and social rights, I would have thought. But we're also a very low tax country, and so we went into this pandemic with massive gaps in our critical essential services, about 3 million people living below the poverty line, and unacceptably high rates of lack of access to housing and chronic situation in terms of homelessness. And so, of course, this critically engages us in terms of our human rights obligations on virtually every front. There's elements of intersectionality in terms of discrimination, for example, the treatment of single parents and the way in which they are forced to meet certain obligations in order to get their social security. If you had human rights embedded in the Constitution, we have checked it, we know that we could tackle that both from a non-discrimination point of view as well as the right to an adequate standard of living. Right to privacy might have been in there as well, but we don't. So here we are. So we went into that period with this kind of settings of Australia having high levels of inequality and particular groups being particularly affected by a lack of access to basic human rights on economic and social fronts. And then we really did some extraordinary things. We demonstrated that we are actually capable when we bring resources together, when we work collectively. Governments are able to deliver. We didn't end homelessness, but we certainly gave most people a roof over their head. And we protected about 3 million people from being in poverty because of the doubling of the rate of job seeker and the introduction of JobKeeper to protect people who would otherwise have fallen onto job seeker back down onto $40 per day. This federal budget, Cameron, I will just share a screen for just a moment here because I want to show this. Can I just check that we've got that? Have you got screen there?
I'm not sure that you've got.
There we go.
It's coming.
You got it now?
It's coming. Yep, we've given you those rights. Go ahead. We've got
Okay,
it.
great. What this budget did was it certainly provided some investments in critical areas of social service, which would definitely have, impacts in terms of economic and social rights. And we did have some, for example, on job seeker, which is certainly the right to adequate standard of living for people who are unemployed. There was a permanent increase of $25 per week, which is over on the little tick side. But in reality, what it meant was people on job seeker had a further cut of their incomes back down into deep poverty. And so in our analysis, that would be considered a regressive measure. But I just want to show that in terms of was it enough? Did we progress in the ways that we would expect a national government to do if it was fulfilling its obligations, both to protect against regressive measures and to progressively realise these key economic and social rights? We've got a bundle of money being spent on personal income tax cuts and business tax cuts. And what you'll see is that tax cuts don't help people who actually need the help. This shows that tax cuts, this is a sort of a distribution by income level, that tax cuts overwhelmingly help people who've got jobs who would be arguably least considered to have an adequate standard of living, if not a very wealthy one. Whereas the bottom 30%, and this slide will show, if you want proof about who actually falls below those kinds of human rights standards, this is an analysis to show that if you're on job seeker, you have acute levels of financial stress. See over on the right-hand column there, that's the people on job seeker. The next group is the non-age pension. So that's a person with a disability, Mary, who's on the DSP. That's their experience, right? And then on very low levels of financial distress, people who have got jobs, on average this is, and people on the age pension, because of course many people have secured home ownership. That will change. That picture on the age pension will change. And I just want to show that in terms of the decisions about budget priorities, dollar for dollar, when a government says, well, we're trying to create jobs, which of course would help people who are in financial distress on job seeker, they're putting most of their money into things like infrastructure and personal income tax cuts. They're the most expensive. One job for every $390,000 is the cost of the tax cuts. That's on the federal government's own budget papers, in contrast to investment in childcare, which costs, sadly, only $50,000 per job. And because of course that's very feminised and gendered. What we will see, we've got no doubt, is over the next period, and I'll stop sharing the screen now.
Thanks, Cassandra.
Where I can, yeah, that's it back there. We will see, again, highly elevated rates of poverty, of deprivation, and because of the lack of protections from forced evictions in Australia, legal protection from forced evictions, we are seeing all over the country people being evicted because they are unable to afford rents. In regional Australia, where typically people on very low incomes would move to try and afford somewhere to live, those rents, of course, are now highly elevated. On average, by 20%, those rents have gone up in the pandemic period. Because,
a minute or so, please, Cassandra.
Pardon?
A minute or so, please.
Pardon?
A minute or so, please, if you could. Yes.
Thank you. Because, of course, as an overall very wealthy country with people who, on high incomes, unable to spend overseas, bundles of cash to spend, people are saying, well, maybe I'll just buy a property down the coast and I've got an option to live down there, or I can get out of a lockdown. Multiple properties down the coast and up the coast is what's going on. And of course, that's then meaning that people on low incomes are being completely forced out. So I had a look, of course, in terms of the national level. At the moment, we only have the Parliamentary Scrutiny Committee when it comes to human rights protections. It is not a pretty picture. I think there are very good people trying to do good work in that committee. Maybe some of you are on this particular discussion. On the cashless debit card, for example, which is a policy which has overwhelmingly targeted and discriminated against people relying on Social Security, controlling the way in which you can spend your money. The Parliamentary Scrutiny Committee, in the face of a legislation to make the cashless debit card permanent, did issue a report saying, warning bells, a bundle of human rights engaged here, but it wasn't prepared to go as far as to say, don't do it. It just said, we need more information. The legislation was, the government didn't blink in trying to push that through, and they've extended all the existing trials. And when it came to the bill to effectively cut JobSeeker back down to $44 a day, the Parliamentary Committee concluded that that was a positive measure because it was a permanent increase. So it took a technical position on it and said, yeah, that's a great one, even though all the evidence was before it that particular policy plunged pretty much everybody on JobSeeker back to a below adequate standard of living. So my conclusion is that the Parliamentary Committee dialogue model does not work in an Australian context. I think it provides a fig leaf over which governments can say from time to time, if they care anymore, that they've got human rights protections at the national level. We are seeing legislation, policy and practice that routinely, daily constitutes, in many cases, gross violations of economic and social rights in Australia. And with the massive shifts that we've seen in terms of income inequality and wealth inequality, we predict we'll see more of that. And so I really want us to get better protections in place on these critical areas, and interested in the commentary from others about where progress has been happening at the state and territory level. Thanks.
Cassandra, thank you very much. And I'll get back to you on this regressive measures point, because you introduced a very interesting idea that that's what's been occurring. And for those who don't understand what a regressive measure is, I might ask you about that and get you to expand that particular subject. But Mary, can I say I'll be giving you equal time, and Katherine and Hugh as well. So over to you. You're on mute, Mary.
Thank you very much, Kevin. Yes, my name's Mary Sayers. My pronouns are she and her. And just a bit of a visual description for me. I'm wearing glasses. I've got medium length blonde hair and I've got a red jacket on. So I'd like to begin by acknowledging the traditional owners of the land that I'm meeting today, the Wurundjeri people of the Kulin Nation, and pay my respects to elders past and present, and to acknowledge that this was and always will be Aboriginal land and sovereignty was never ceded. So Children and Young People with Disability Australia is the national representative organisation for children and young people with disability aged 0 to 25. And the majority of our members are either families of children with disability or young people with disability. And so when we look at the rights and the human rights of children and young people with disability, their human rights are often overlooked or missed in public policy that's specific to children and young people more generally. And the distinct needs and strengths of children and young people are often missed in disability policy as well. So the COVID situation was a classic example of where children and young people with disabilities rights were really undermined through that process. So we launched a survey of our members just 5 days after the World Health Organisation declared a pandemic. And we worked with the University of New South Wales, Canberra, Professor Helen Dickinson, and the University of Melbourne on analysing that data. And in that report, we found that 82% of respondents said they lacked information specifically for children and young people without disability. And that was consistent throughout the 5.5 weeks. And remembering this was a time when stockpiling was occurred. So the basic essentials that children and young people with disability needed, like hygiene products, sanitation products, special dietary products, they couldn't access the basics during this time, and there was no planning for their particular needs, and many had their services cancelled through the NDIS. And the overall finding from this first report was that the response to COVID-19 did not appropriately target the needs of children and young people with disability and their families, and that was backed up by the Disability Royal Commission. The situation in education was particularly dire, and we launched a second report, again with over 700 responses, and we titled that Not Even Remotely Fair, the play on remote, because that was a time when we were going into remote education. And we had over 700 responses and over 1,000 free text responses. And there we found 72% of students with disability were more socially isolated from their classrooms, such as being excluded from working with their non-disabled peers and not being included in virtual technology. And there were significant reductions in the usual support that's provided for students with disability. What's really sad is more than half did not have regular support from their education provider to check in on them. And so when we look at the Disability Standards for Education and the Disability Discrimination Act, there was distinct discrimination that happened against students with disability during the COVID pandemic. And so whilst this situation occurred, there were very few mechanisms to actually ensure their rights were upheld. And one of the challenges is, as they grow and develop, children and young people with disability interact with so many systems and structures, both disability and non-disability specific. And when these systems don't encompass the needs and strengths of children and young people with disability, the group is further marginalised. And we saw this during the pandemic. And so, for example, children and young people with disability have very few avenues for their rights to be protected. And the UN Convention on the Rights of Persons with Disability, the specific Article 24 around the right to inclusive education is a classic example of that. So General Comment 4 by the UN Convention elaborates on what inclusive education is and what it is not. And it is not being segregated from your non-disabled peers. It's not being put in a special school and not in a mainstream school. Yet in Australia, we have a rejection and a contested space around education. And the Article 24 says it requires state parties to progressively realise a specific and continuing obligation and to move as expeditiously and as effectively towards full realisation of the right to inclusive education. And this is not compatible with sustaining two systems of education, mainstream and a special segregated education system. So COVID exacerbated the existing disadvantage that students with disability faced in their education and a whole range of elements in their lives. And I've probably just ticked over 5 minutes, but I'd really be interested.
No, please continue. I give you equal time. You've got about 4 to go if you want them.
Okay, and look,
you did tell me yesterday you could talk for days about this.
Look, and we have the Commonwealth Government who has rejected that a two-tiered system or two parallel systems of education is consistent. The Commonwealth has said their interpretation of the UN Convention is maintaining two parallel education system is consistent with the right to inclusive education, despite the general comment. And in September 2019, The UN Committee on the Convention on the Rights of Persons with Disability, in its concluding observations following its review of Australia's compliance with the CPRD, expressed serious concerns about a range of issues and strongly criticised, among other things, the current legal and policy frameworks and the general failure of Australia to harmonise domestic legislation with the CPRD. And so, notwithstanding Australia's ratification of the CPRD in 2008 and the Disability Discrimination Act, in relation to education, the fundamental right, human right of children and young people to inclusive education continues to be contested in this country, and it comes down to a parental choice discussion as opposed to a human rights. We, as a national representative organisation, do not criticise parents for any choices they made, because if they're faced with a non-inclusive mainstream education system, that is not a true choice. And so the veil of parental choice is used as a instrument to actually reject Australia's obligations under its international human rights treaties that it's signed up for. So this range of human rights instruments expressly categorise segregation as an unlawful form of discrimination against them, which is not compatible with the right to inclusive education. And the Disability Discrimination Act and the Disability Standards for Education are largely ineffective in realising inclusive education. And that's why we're so excited about the potential of a human rights charter to actually realise the rights that Australia has, because at the moment we're a long way from our international obligations being realised, not just in education, but in a whole range of other areas for people with disability. So I'll stop there, Kevin. Thank you.
Mary, thank you very much. And again, you've stimulated something in my own mind because of your very effective and comprehensive reference to the UN rights position as regards Australian compliance. And I might ask you later, just how effective is that kind of advocacy? Does it resonate or not? How can it be made better, and what are the deficiencies? So I'll come back to that. But Katherine Temple from the Consumer Action Law Centre, your turn now.
Thanks, Kevin. Thank you very much, everyone, for having me today. And I also want to acknowledge the traditional owners of the lands of which I'm calling from today, people of the Kulin Nations, and pay my respects to elders past, present and emerging. So at Consumer Action, our lawyers and financial counsellors are really on the front line when it comes to the COVID crisis, but also our recovery. Our FCs and lawyers speak to around 10 to 15,000 Victorians every year, offering them advice and assistance. Many of the people calling us are in really severe financial distress, and they're often juggling multiple debts and facing significant hurdles in their lives, such as relationship breakdowns or job loss. Pretty consistently, the top two issues raised by people calling our financial counsellors at the National Debt Helpline are credit card debt and utility debts. And, you know, I think we're looking at this through a human rights lens, need for financial inclusion, sort of economic stability and access to essential services, you know, really are reflected in those frontline calls a lot of the time. And many people calling us really are worrying day to day about how to keep food on the table and keep a roof over their heads. And I think to Cassandra's point, you know, COVID-19 and the response to COVID-19 did show us in many ways that there could be a different way forward. And no doubt there were, and there still are a lot of people who are struggling. But you know, the increases to JobSeeker and JobKeeper, you know, it lifted so many people out of poverty for the very first time in years. And we actually saw calls to our financial counsellors decrease pretty significantly last year. We only saw one energy disconnection between March and December in 2020 here in Victoria. That was compared to over 36,000 disconnections the financial year previously. You know, we saw banks defer loan repayments for hundreds of thousands of Australians, offering hardship assistance on a massive scale. So I think, you know, it showed that government and industry, you know, really could step up when the need was there, and in an acute way. But as we know, the lockdowns are ending, and so some of these additional supports and business as usual is really looming now. And calls to our financial counsellors and lawyers are increasing yet again. And we are seeing lots of households returning to that financial struggle with the end of the job seeker supplement, and which had been a lifeline for so many. And I think energy debt really is a key indicator, and we are seeing increasing numbers of people struggling to make payments. So in March alone, around 2,400 Victorians had their energy disconnected, and debts and the amount of debt is accruing. And banks are starting to push people for loan repayments, and lending again is at really record levels. So I think it's clear, while government and industry stepped up in many ways last year, we can't rely on industry alone for an inclusive recovery that really puts human rights at the forefront. Recent research from the University of Sydney found that 22 ASX listed finance companies, including the big four banks and Afterpay, were largely failing to manage the risk of potential human rights breaches in their work. And that's, not really of huge surprise probably for us who work in the area. I mean, the finance sector has been dogged by human rights related incidents and breaches in recent times, many of which were covered in pretty excruciating detail during the Banking Royal Commission. That's anywhere from poor treatment of customers, money laundering, poor product design, kind of really impacting on people's economic security. As I said, credit cards, one of the top two reasons people call us, and often those cards were issued 15, 20 years ago. So the lag time of the impact of those sort of poor practices can be quite significant. So the research also looked at the impact those institutions have on society through their public policy positions and their lobbying. And big financial institutions, they seem to continually struggle to walk the talk. They're often saying the right things, but when you kind of get to Canberra, or you having these conversations, you realise that they are often lobbying against some pretty important and significant consumer protections, and they don't really often want to tackle the cultural problems that are at the core of their business models, or accept law reform that would really deal with those issues. And in a lot of ways, that only really serves to reduce trust and confidence in that sector. And for example, the Australian Banking Association, which is one of the peak bodies for the banks, recently came out in support of a government plan to axe responsible lending protections for most consumer loans, and that there's just absolutely a core consumer protection in lending that our FCs and lawyers use every single day in their work, with the very clear stated aim of moving away from lender beware to borrower responsibility. It directly contradicts the first recommendation of that Banking Royal Commission, and kind of flies in the face of a lot of the findings around the terrible lending practices we saw in the Commission. And so I think, it's obviously very disappointing to see industry supporting such a regressive move. But I think it is kind of a good reminder that, while I think industry have a very important role to play in promoting the economic and social rights of people here in Australia, to look at a long-term recovery that includes all people, we really do need governments and regulators as well to step up. And I think that we really do need a legislative framework like a charter that's then supported by appropriate regulation to achieve those sorts of outcomes, and achieving the kind of the human and human rights sort of centered approach to how we work and the laws that are passed. So particularly for people facing disadvantage or vulnerability, who often just don't have that seat at the table that some of these big industry lobbying groups have in Canberra. So and I think as well, just to remember the glimpses of positivity we saw during COVID. I try to come back to that. I think we showed that we could do it if we want to, and I think there's a really strong association between the realisation of human rights and the alleviation of poverty, and I hope we can get back to it. That's it from me. Thank you, Kevin.
Katherine, thank you very much. We'll move shortly to Hugh de Kretser from the Human Rights Law Centre, but before we do, can I ask you now to consider your questions, post them in the Q&A box. I'll turn to those immediately after Hugh finishes. Thank you, Hugh.
Thanks, Kevin, and great to be here. And I'd like to acknowledge that I'm here on the lands of the Kulin Nation in what we now call as Melbourne, and also recognise the acute importance of the issues we're talking about to Aboriginal and Torres Strait Islander people who for many years in Australia have been subjected disproportionately to human rights violations through injustice and dispossession, and a Human Rights Charter, which is one of the topics we're talking about today, would help to address that. I wanted to zoom out by saying what are human rights? What are we talking about when we're talking about human rights in this context? Human rights are international standards or rules that governments around the world, including the Australian government, which played a leading role in developing the international human rights framework, have agreed are the essential things that everyone needs to have a decent, dignified life. So they're things like our right to housing, to health, to education, to food, water, to an adequate standard of living, our right to work, our right to vote, our right not to be locked up unfairly, our right to a fair trial, etc. Our right to life, particularly important in the context of a pandemic, and our right to health. While Australia signed up to the international treaties that protect those rights, and Mary's talked about this, Australia hasn't properly implemented those obligations and those rights in our domestic law. And so that means that Australian people have less protection of their human rights than people in equivalent democracies around the world. And obviously we're trying to change that through a campaign for a national Charter of Rights to embed those human rights in our domestic law. And what a charter would do is it would require governments to properly consider human rights when they're developing laws, developing policies, when they're delivering services. Think human rights before you act. And it would require governments to comply with human rights when they're delivering those services or developing policies. And it would the experience from the UK, New Zealand, Canada, the early experience here in Australia with state-based human rights charters, and we have them in Victoria, Queensland, and the ACT, is that when these charters work properly, they have a really important preventative role because it focuses the attention of government on the human impact of the things that government does. It helps to make sure that people don't fall through the cracks. It helps to make sure that policies are developed in a way which is responsive to the needs of people and communities. And so working properly, it has a really important preventative role in stopping human rights from being breached. But it's incredibly important also for governments to take human rights seriously. And Cassandra talked about what we do have at the federal level is a parliamentary scrutiny mechanism where new legislation which is brought into the parliament has to be assessed against human rights standards. That committee by and large takes its job seriously, in a very diplomatic terms, raises concerns with legislation. Those concerns are typically completely ignored by the minister or the government who's actually bringing in that legislation, even though it's often government MPs who are raising those concerns through their committee role. So to have human rights taken seriously, it's absolutely important that you have, that people have the power to take action if their rights are breached, that there are enforceable legal obligations, that rights have remedies attached to them. That's the introduction to sort of the state of play in Australia. The other speakers have talked about the great opportunity that we have coming out of this crisis to say, we don't want to go back to business as usual. We saw that when governments listen to the public health advice, listen to the evidence, they can effectively protect life and health. And I think we should be really proud of the record we have in Australia of governments responding to the threat of the pandemic and protecting life and health, and particularly the life and health of the most vulnerable members of our community. There's many instances where governments got it wrong, but I think Australia's track record is good on a world scale. The other thing that we should be proud of is the responses that the other speakers have talked about in terms of the lifting people out of poverty, addressing homelessness, and that needs to be embedded in the recovery. We shouldn't go back to business as usual. When you look at rights like housing, health, and education, the obligation under international human rights law is to progressively realise those rights. That means we should be using our available resources to achieve, for example, the highest attainable standard of physical and mental health. We shouldn't be going backwards. Cassandra's pointed out how we are going backwards in terms of social security. We're going back. Catherine's pointed out how we're going backwards in terms of poverty. These are things that we should not accept, and we can talk later about how a charter might help to actually prompt government to make sure that we don't go back to business as usual, and that we actually embed fairness and equality and dignity and respect into the heart of government decision making and policy and law making in the future.
Thank you very much. Perhaps Cassandra, with the comments that Hugh just made, it might be the time to turn to you before I ask a very interesting question from Julie Collins, which is posted in the chat. Others, please post. But the question relates to the concept of a regressive measure, and you're really hinting here that going backwards might be a breach of international human rights law. Can you explain what a regressive measure is and how it might be in breach of those rights?
Thanks, Kevin. And can I also acknowledge country? Pay respects. I'm on Gadigal land. I was on a previous event, like literally back to back, and
yes.
I just realised that I did not in this setting acknowledge First Nations leaders and communities. And of course, you talk about regressive measures, Kevin, I can tell you, for Aboriginal and Torres Strait Islander communities, it's hand over fist at the moment. So it essentially means that in relation to, for example, the right to adequate housing, and Hugh has expanded further on what that right really requires of governments, which is to progressively realise the right to an adequate, adequate housing to the maximum of available resources. And so the obligation is for governments to work to improve things, not to make things worse. So the positive obligation is one which is often quite hard to pin down, because you can see the notion of the maximum of available resources is a debate. And of course, governments can say, well, we've got a number of competing priorities here. That's why I wanted the pie chart to show you that all the dollars are going into the tax cuts. And they might say, if they'd said, oh, because we need jobs, because that's going to help everybody to afford their house, that'd be one thing. But when you do the analysis of what's better to create jobs, they are the least efficient. So that's where, could we argue that? So that's often hard debate, isn't it, to really pin down that. I mean, in countries where there are constitutional rights that set out that obligation, there's been some pretty interesting case law, but no doubt, to Hugh's point, it creates important pressure on governments to put the resources in. A regressive measure is much clearer. If a government action makes a person's situation worse and takes them back down even further below the minimum human rights obligation, then it engages, and if you had a remedy, we would have a claim. You would have a claim against government. So for people who are on social security, we would argue, it'd be interesting to see where it ended up, that the government, having demonstrated that they introduced legislation to increase job seeker, to deliver for people an adequate standard of living, if you're unemployed, that the act of cutting that rate back down well below the poverty line was a regressive measure.
Yes.
Good luck for us. Here we go, because actually the Parliamentary Committee took a different view on that. There are other examples where, for example, the third-party verification policy is one where the government introduced that clearly discriminated against single parents. What it said is, we don't believe you. When you say you're single, we don't believe you. You're going to have to go down the road and get somebody to sign a statutory declaration to say you're not having sex with anybody else in a way which might be considered an intimate relationship. Now, we don't require that of anybody claiming tax deductions, both very gendered, right? But we're going to say, single mothers, we think you lie a bit about what you're up to, so we're going to get you to go down the road and get somebody else to get a stat dec on you. Shocking, actually. And we would have considered that absolutely a regressive measure. It's a credited barrier for people to get access to single parents with no justification whatsoever.
Thank you, Cassandra. That's very clear. Back to the question from Julie Collins. I'm not sure whether this is for Katherine or Cassandra. Perhaps you, Katherine. It's on the cashless debit card. The question is: given the extensive failure of the cashless debit card, are they a breach of human rights law and/or the Australian Constitution? Then there's a comment as part of that question: are the government breaking their own laws by continuing to disadvantage the most vulnerable within our communities? Can they be held accountable for the coercive control that's involved in relation to these cards? Katherine, are you across cashless debit cards or not?
I'm happy to say some brief comments, but Cassandra's probably more across the detail, to be honest. But yes. I mean, I think, we have really serious concerns about the cashless debit card, and I think all attempts so far to hold the government to account for the absolute destruction this will cause in the communities that it's being rolled out in, unfortunately, hasn't sort of dissuaded them from continuing. And I think the impact it'll have on people's everyday lives, but also the lack of choice, and even in terms of who the provider is at a really basic level for in our economic policy. We're also often talking about how important competition is and choice and consumer choice, yet we have this policy whereby people will have no choice about what card provider they use to spend their money, let alone how they spend that money and in what outlets. But I might leave it to Cassandra to talk more.
Yes, thank you.
In more detail.
Cassandra, thank you.
I will circulate the link for you to the committee report. So the Parliamentary Scrutiny Committee did look at the cashless debit card, and it confirmed that the card engaged human rights both positively and negatively. So it heard evidence that the cashless debit card was helping to protect children, to provide more food, etc. And it was also hearing evidence about invasion of rights to privacy, discrimination. And so it cast its net very wide. It said, we don't know where to land on this, and posed a whole lot of questions for government to answer. But to Hugh's point, confirming that essentially what happens with those reports, which are often very rigorously done, governments just ignore it. And I'm not aware of the government having answered those questions at this stage.
Yes, thank you. Mary, can I ask you a question? We had a pre-meeting yesterday, and we were talking about the effectiveness or not of state charters of human rights. And I wanted to ask you whether you have observed that in Victoria, where it's been in place for over a decade, there has been an increase in observance of human rights with respect to children and young people with disability, or not?
Look, sadly, I think not in terms of children and young people with disability. So when we go back to my opening remarks around the UN Convention on the Right to Inclusive Education, Victoria is one of the states that has increased its segregation in education over the last 10 years. It has also got a stated policy that it supports a parallel education system. We also have continued investment by government in new facilities. So rather than investing money into ensuring inclusive education, that every child and young person can attend their local primary or secondary school, there is a strong commitment to a parallel education system. And I think the challenge is, and we have a saying in disability, you can't be what you can't see. And for many children and young people have never been visible in education systems because they're separate. But we've got over 50 years of evidence that says when children and young people are fully included in education, their employment outcomes are better and their lifelong trajectory is better. However, we've got these legacy systems of things like group homes in disability. We've got legacy systems of institutionalisation, that still quasi-institutionalisation that still happens in disability. And when we look at the child protection system, and we do numerous freedom of information requests to try and ascertain whether the rights of children and young people with disability in out-of-home care systems, including Victoria, are having their rights upheld, including their right to be NDIS participants, including their right to inclusive education or even education per se, you just can't get it. So whether that's because the Charter of Human Rights in Victoria is not expansive enough to cover the rights of children and young people with disability, and people with disability generally. But we still have, and I guess I wanted to say one last thing, which was about, we have Royal Commissions and an explosion of Royal Commissions that actually is about things that go wrong. At the national level, we've got Aged Care Royal Commission, we've got a Disability Royal Commission. In Victoria, we've got a Mental Health Royal Commission, Family Violence. What we've got is continued stories of human rights abuses that come out with recommendations from Royal Commissions, but there's really no mechanisms other than government saying, yeah, we agree or we don't agree, to actually ensure rights are upheld. So in the future, I would rather see much less focus on policy by Royal Commission and much more focus on human rights and the legislative protections, because people have no rights to complain. In education, if their school does wrong by the child, if they're told that they're not welcome at their school, they're better off going to the special school up the road because we don't have the funding or the resources to support you. That is actually discrimination. Yet there's very few mechanisms for people to get their discrimination addressed. And so we've got some really deep structural and systemic inequality in this country that's just not getting addressed.
Yes.
So I'll stop there.
Yes, no, thank you. Thank you. Powerful words, Mary. The Mental Health Royal Commission has reported. It's made a large number of recommendations, will probably lead to massively increased funding. But the program of reforms, policy changes, funding mechanisms, which is recommended, are underpinned by human rights. And I would hope would lead to a revised act with much greater emphasis upon those rights. Hugh, when we hear Mary talk in her presentation, very, very powerfully and comprehensively about rights, she refers mainly to the CRPD, which are specific rights in relation to people with disability. Now, the Charter, of course, is a general instrument based on the ICCPR and the rights there in the way of equality, non-discrimination, some rights with respect to children and so on are very general, not as developed as the CRPD. I wonder whether her point that the Charter's not expansive enough is a really important one to make.
Yeah, I think it is, and I just wanted to furiously agree with Mary and yourself, Kevin, about that the sort of policy by Royal Commission failures that we're seeing time and time again. And when you have these inquiries that look at fixing systems that are failing, what they tend to recommend is a human rights approach. And what we need to do is embed that human rights approach before the failures happen. So in aged care, if we had a charter of human rights that protected the rights of people in aged care facilities, you wouldn't need the Royal Commission if you actually gave people the rights and properly monitored the enforceability and implementation of those rights. And so that's one thing that a charter would do in terms of that preventative role. Mary's points about the effectiveness of a charter and the model we've got in Victoria is modest. So there is a right to bring legal action, but you can't get compensation, which is a problem. The right to bring legal action is not a direct right; it's an indirect right, which needs to change. It should be far simpler to take action. You should be able to take action in the tribunal in Victoria rather than having to go to the Supreme Court. And these are things that have been identified and recommended in terms of improvements that the Victorian government needs to make. Importantly, as you point out, Kevin, the Charter in Victoria only protects really only civil and political rights, not economic, social, although some cultural rights, particularly for Aboriginal people, are protected. And we're seeing finally some movement and some interesting developments there around how those Aboriginal cultural rights can be better utilised to support Aboriginal people. So the right to education is not protected in the Victorian Charter, but it is in the Queensland Human Rights Act. And there is a form of the right to health in the Queensland Human Rights Act. And I think we need to be doing work in Queensland, looking at how we can use those rights to engage with government to, for example, look at health outcomes in remote Aboriginal communities and say you actually have a legally enforceable obligation to implement the right to health or the right to education in rural and regional centres, and say how can we use that legal hook to hopefully constructively engage with government and say you need to do better, but with the threat that if government doesn't take that constructive engagement seriously, there is a legal obligation that is enforceable by people whose rights are being breached. So with Mary's point about inclusive education, I don't know enough about that issue to comment. Like for me, it seems like an equality issue that discrimination law and the right to equality should be playing a role. So we should talk offline, Mary, about that issue. But I would have thought that also the right to education, if that was properly implemented, and obviously we saw in the pandemic, if you didn't have internet at home, your right to education, or if you didn't have reliable, it was completely compromised, and the rights of kids with disability in particular compromised. And so these are the things that we need to be creating legally enforceable obligations. The McKell Institute released a report recently to say we should have housing as a human right. It's good to see the budget response from the ALP trying to improve the situation in housing, but the concept of making it a human right is saying instead of a charity handout from government to someone in need, this is an absolute core responsibility of government. This is a promise that government has made, and the community, the public, can hold government accountable to that promise to deliver on these fundamental human rights that are the essential things that people need for a decent, dignified life. So that's the promise of a charter. We're running out of time, Kevin. I did research about your question yesterday about a human rights approach to the budget, and I saw that the New Zealand Human Rights Commission had actually done a submission to, I think it was the 2019 budget in New Zealand, which was the wellbeing budget, and they said it's great that you're viewing these things in a wellbeing sense. Even better would be to do a human rights budget impact assessment every time you do a budget.
Let's come back to that. I want to go just a little bit over time, if people can give me 1 minute, because an important question has come in from Geraldine Johns Putra, which relates to accountability for business, a non-state actor for human rights. Katherine, I'm going to direct this to you, and I'm going to make the question very specific, if you could briefly answer. Have the Ruggie principles on business and human rights had an impact in the consumer credit sector?
Sorry, Kevin, could you repeat that?
Yes. Have the Ruggie principles on business and human rights had an impact on the consumer credit sector? And are those principles advocacy tools which you can use in your work?
I mean, I think the most sort of effective tool we use in our work are those responsible lending provisions that I mentioned in those first 5 minutes. And I think they remain core to how we seek redress for people who have been lent to irresponsibly. So look, I think the finance sector as a whole is a long way behind when it comes to human rights. So I think they need to do more in terms of making that core to their business and their policy positions. And
Yes.
so as such, I don't know whether human rights is really factored in much to how they're operating at this stage. Yeah, and so that kind of black letter law has been the most useful. Yeah.
Yes. Well, they should be, and I think the principles and the structures hanging underneath the principles might be another avenue of attack with respect to human rights breach in relation to consumer lending. But that is truly all we have time for. Oh yes, Cassandra, your hand's up.
On that question, for example, is energy companies have where they show human contact before a disconnection, virtually no disconnection ever actually happens.
Yes.
Now, we can try, can't we, Catherine? We're going to keep pushing to say to the corporations that needs to be an absolute minimum standard for you, but we could have legislation, because ultimately this is government's responsibility to say, if before a disconnection goes ahead, you must connect with the human reality of the consequences of a disconnection. And that is absolute core to a human rights approach.
Yeah, I agree, Cassandra. And those remote disconnections remove that human element, and that's why you end up with 36,000 in 1 year in one state. So no, I totally agree.
Yeah.
We actively use those principles, Kevin, in our advocacy with finance sector, with large corporations who promise to uphold human rights. That promise then gives you legal hooks to actually enforce it.
Here's an offer to you from a director to a director, Hugh. Why don't we do a seminar on what a human rights-based budget might look like, focusing on the budgetary aspects of it and the way in which service delivery it can be linked to rights.
The gender budgeting is an example of that. You would do that as part of a human rights budget.
That's great. Cassandra, would you like to be involved?
Love it. I love budgets.
Okay, Mary? Catherine? Okay, I don't take any of those yes answers as being real until confirmed in writing off screen. Can I thank Cassandra Goldie, the Chief Executive Officer of the Australian Council of Social Service, Mary Sayers, the CEO of the Children and Young People with Disability Australia, Katherine Temple, the Director of Policy and Campaigns at the Consumer Action Law Centre, and Hugh de Kretser, the Executive Director of the Human Rights Law Centre, for a fascinating discussion in our seminar today. Can I end by thanking all of you, many participants, for staying online, for joining us and discussing this question of fundamental concern, a National Charter of Rights for Australia. Bye for now.